You very much, Joy. Good evening, and welcome, and thank you for joining this session today. We are examining how trust work under the South African law, and specifically looking at the basics just in tax administration, how tax works, and what the benefits of a trust are. And really, the key message with trusts is trust do not make assets disappear, but that it moves them into a controlled environment so that it can assist with legacy planning for families. So in terms of tax implications, trust still have tax implications, but it is at least one understands what the tax implications are when it comes to trust compared to an individual. But where a person needs to look at long term, a trust is actually one of the best ways of preserving or transferring your legacy if you have got children. And let me also indicate that a trust, this session is not advice, but it's just for general knowledge and understanding. And where a person needs bespoke or specific advice, you can contact us on info@mmcpadvisors.co.za, and we can assist with specific issues with regards to a trust. My name is Ntabi Singh Maidi. I'm a chartered accountant and I hold an LLB as well. And I'm the principal at MMCP Advisors. So this evening we will be talking about about trust, specific laws and taxation. I would like to request that if you are joining us for the first time, or if you would like to know more about what we do at MMCP, kindly visit our YouTube page, which is at MMCP Advisors. And we are in different social media pages. You can just search MMCP Advisors. You will be able to connect with us as we publish, or as we publish different nuggets on a weekly basis in terms of trust. So for those that had attended our last session where we were talking about estate planning, I indicated that there are 6 components to estate planning, and we spoke last year. We spoke about wills and testaments. Today we're talking about trusts. Last time we spoke about powers of attorneys, healthcare directives, beneficiary designation, and letter of instruction. So that's what today, because trusts take much, you need to go into more detail when you deal with trust. This session is meant really to assist with the understanding of trust. So just as a precursor to our conversation, we're saying don't let the master's office, the master of the High Court, decide the future of your children. For those that do not know, if you die intestate, meaning that you die without a will, that means that the master of the High Court is going to appoint executors for your estate, and your estate is going to be administered by the master of the High Court. And that process can take between a month to a year to 2 years for those that have gone through the process. So for you not to go, for your family not to go through that, let's try to make sure that our estate planning is on point, and we are doing something about that. So if I may ask, just by a show of thumbs up, has anyone who is in the audience put up a trust, or are you considering to register a trust? Anyone? Joy, did you allow for reactions and all of that? Okay. I'm assuming that anyone, thank you, Joy. I'm assuming that everyone who's here or who's watching this is considering registering a trust. So let me start off with just a simple thing, a definition of a trust, so that one understand. So a trust is an arrangement in which property is placed under the control of trustees. Let's understand the control part. And there's also the trustee to be administered for someone. And that someone is the beneficiaries or for impersonal purpose. So there is control, there is parties to a trust, meaning that one needs to understand the role that each person holds. And also, let's understand that a trust is not a company. When you register a trust, you do not register a trust at the CIPC. Companies are registered at the CIPC. However, trusts are registered with the Master of the High Court, the trust division. And let me also indicate that legally, a trust is not a juristic person like a company. So it doesn't have an independent personality. It cannot be sued, or a trust cannot sue in its own name. When you look at the difference between a company and a trust, all of the things that I've indicated above, a company can do that. So with a company has got a legal personality and it can sue and be sued. But when it comes to a trust, it can't do any of that, because what it does, it acts through the trustees. At every trust has to have trustees. And in terms of legislation on the Master of the High Court, there is a requirement for a certain number of trustees, depending on the type of trust that you are registering for. However, for income tax purposes, the taxman says, I'm going to see a trust as a separate person. So on the other side, it was a company, but when it comes to tax administration, is a separate person, meaning that it can also be taxed in its own right, not the trustee. So when SARS looks at taxing when SARS when you do the registration, you do the registration of a trust and not the trustees, because the trustees will have their own tax numbers. Now, so then what it means then, so what it means in terms of when you transfer a property from your own, like from an individual or a person into a trust, it means that that trust holds title to that property, and the trustees are going to control that property. Yeah? So we need to understand that the separation of a trust and the personal property is non-negotiable. Yeah? So you cannot 1 month say the property is in my name, the next month it's, so you cannot choose that. Once you transfer it into a trust, it means you must go and register it with the deeds office. You will see that when you register a trust, you need a trust deed, because that trust deed must also be registered. So that is just what we're saying in terms of what a trust is, you really need to understand that. I'm also finding that there's a lot of people who are coming through to us asking that they would like to register a trust. And when you ask them certain questions, they don't actually understand why they're actually registering a trust. So there's three types that we find in South Africa. The first one is an inter vivos trust, whereby the trust is is created by the founder or that one of the trustees in their lifetime. Me, as Ntabiseng, I'm still alive. I register a trust for my own family or for my business interest. So that is an inter vivos trust. Then we've got a testamentary trust. A testamentary trust only comes into effect when the founder dies. And a will usually create a trust. For an example, you write in your will that I would like to create a trust and my properties will be transferred to a trust on death. So that's what is going to happen. So your will actually help you to transfer your legacy to your heirs through a testamentary trust. Then we've got special trusts, and the special trusts come into effect because SARS categorizes them as special trusts. And this is going to include a disabled beneficiary or minor children under the age of 21. That's how SARS is going to class. Those are some of the prerequisites for having a special trust. In the last week, I was doing a session, and there were ladies who were saying, "I've got children. We've got children with special needs. So how do we actually how do we preserve legacy, or how do we transfer legacy to our kids with special needs?" So that's actually what you use. Then you're going to use a special trust. You'll also notice that a lot of the guys, people that have received RAF benefits, sometimes their benefits, depending on who is managing their benefits are going to be transferred into a trust because somebody is going to assist them in managing and in controlling their funds. Yeah? So there's this thing of a revocable or irrevocable the trust. So this is more of an American classification, but in South Africa we don't use it that much in terms of whether it's a revocable or an irrevocable trust. That's then. So when you create a trust, for those that are planning to create a trust, you need to understand that there are parties to a trust. When you create a trust, first there needs to be a founder or a donor. So a founder and a donor is somebody who's going to be transferring or create or transferring the property. So that person creates the trust for estate planning purposes. Now, so that person can choose to participate in the activities of the trust, or they may choose not to participate in the activities of the trust. Whereby you can say, I'm just going to donate funds, but I'm going to appoint trustees to actually manage. Remember when I spoke about the definition? I'm going to appoint trustees to actually manage and control the trust. So that is the second leg, the second party to a trust agreement. One needs to be quite aware. There is a word there that says you accept fiduciary office. The one mistake that I find is that a person, I would be given a name of a person that, yeah, this person can be a trustee in my trust. And the specific questions that the acceptance form will ask you, and they will ask you whether you have managed a trust before or you have got an understanding of how the trust works, because they give you a fiduciary responsibility in managing the trust. That is a very important position to hold in a trust, because you are acting together with the other trustees. You are acting jointly for the management or the control of that trust. Yeah? So, and unfortunately, there is personal liability that one can incur if there are breaches to the trust deed, because the trust deed will indicate how you need to behave as a trustee. And if they find that you have breached some of the terms of the trust deed, there is personal liability. So whenever you choose a trustee, make sure that it's someone who understands the law, someone who understands their duties. The other one is you also need an independent trustee. And this is a recommendation more by SARS. So whereby when you are managing or when you are in control, you need someone who will not be biased. Remember, at some point when you are trustees, you are going to be distributing income to the beneficiaries. So there is a recommendation, and this is taken strongly, and that you need to have an independent trustee in your trust. The other thing is, lastly, it is said that all trustees must act with care, diligence, and skill. I've spoken about experience in managing a trust. The next one is there needs to be beneficiaries. So the beneficiaries will receive vested rights, or they may be at the discretion of the trustees. So and you as the founder, you can be a founder. Let's say it's me, Tabi, saying, I want to transfer my property into a trust. I can be a donor, founder. I can also be a trustee, and I can come back and be a beneficiary in the trust. So you need to be able to identify the beneficiaries. And when it comes to beneficiaries, you have got 2 or 3 types of beneficiaries based on the type of, again, the type of assets you have in a trust. Say you have got a property, my place of abode, and I put in my trust deed that my son will own the property until all his dependents, or all his heirs, to infinity, meaning that my son can only enjoy the use of the property. Then I can also have other rights where I am saying that someone else will receive the income. Let's say that the trust receives dividends, or received rental income of property. So if there is income in that trust, so other beneficiaries, you can also choose as to who receives the income from the trust. So you need to be able to identify who will be able to receive capital payments, who's going to be receive income payments in a trust. So, but that you can only, you need to talk to someone that can actually help you to structure that in terms of who receives the type of benefit from the trust. The last one is the master of the High Court. So one thing that you need to be aware of, you cannot just create a trust on your own. A trust has to be registered with the master of the High Court, and you cannot act as a trust before you get a letter of authority, because the letter of authority is the one that actually gives you rights to actually transact on top or on behalf of the trust. Usually, the master of the High Court will give you a number, and the number will start with an IT in front. So whenever you want to transact, make sure that you have got a letter of authority. Then let's talk about what brings the trust into effect, and how do we become accountable. For those that have registered trusts before, will remember that in 2023, there was an amendment whereby every trust, we needed to go and upload beneficial owners. So there needs to be transparency in terms of who are the parties in a trust. So the Master of the High Court will require you to have those details, that the trustees are these names, the beneficiaries are these names, until to an extent where there is a warm body, because they want to see the beneficial owner. So you cannot say a company is a beneficiary of a trust. They want to see the warm body at the end. So that is that. So I spoke about authority to act. I spoke about the trust deed. So when you register a trust, you need to be able you need to submit a trust deed, and that trust deed is going to be kept by the master's office. So what happens thereafter? You need to be able to keep separate records for your trust. So if a trust has got its own bank account, you need to open a separate bank account for the trust. You need to be able to keep records, because you are going to prepare annual financial statements, and you are going to submit your ITR 12T, which is your income tax return. Yeah. The next one is, I spoke about fiduciary standards, where you have to act with care, diligence, and skill when you manage someone else's assets. And yeah, so you must also make sure that when there is a change in the auditor, or a change in the trustees, you need to submit those changes to the master's office, so that they can actually update the records on their side. That's that. So what makes a trust valid when you go and register a trust? The law looks at your intention in creating a trust, because there is something called the sham trust, or the alter ego doctrine, whereby a trust is created to hide certain things, or for illegal acts. So there is a case actually whereby it was determined that what was the intention of the people in creating the trust. It's Badenost and Badenost versus Badenost, husband and wife, whereby the master of the High Court actually looked at what was the intention at the time that the founder created the trust. So you need to be very clear in terms of what you are doing, why you actually want to create the trust. So the next one is that it has to be a valid trust document, instrument. So there should be a trust deed. Is it an inter vivos trust, or what? Or is it a valid will? Next, there should be certainty that there is property, especially immovable property. that is actually in there, and there should be beneficiaries. It doesn't make sense that you have got a trust, but you did not register any beneficiaries for the trust. Lastly, all trustees that are acting as trustees must make sure that they accept trusteeship. You cannot just appoint someone as a trustee without them accepting trusteeship. So let's talk about the master's office process. Um, so there is a process that we actually go through when we register your trust. From our process is there's a form that you will complete where we try to bring everything together, your intention, the name of the trust, who's going to be the trustees, and that we provide you with that. We draft a trust deed for you, and all of the trustees sign the trust deed, including the independent trustee, and the process can take between 4 to 8 weeks. Previously, I've seen other trusts that it took probably a year to register a trust just because of the slowness from the master's office and some of the information not being complete. So you need to make sure that by the time you bring in your documents for registration, all your documentation, all your documents are proper. You have signed before a commissioner of oath. You have supplied IDs that are visible. You have got proper copies of your IDs. So you do that. So we lodge that with the master's office. And after a few days, they will provide us with a letter of authority. So that is the process. Usually that process is done by accountants, lawyers, and that they can actually assist you in registering a trust. What is also very important to note is that you need to have an accountant or an auditor for that trust. And the reason is because somebody is going to be in control of someone else's property. There needs to be someone who can do the accounting process. So, and that auditor or the accountant's name is required upfront when you do the registration. Then what happens after you have registered the trust? You must make sure that you register with the receiver for a tax number. You must maintain separate maintain separate bank account and keep accounting records. And on a yearly basis, you need to update the beneficiaries of that trust. Yeah? So that's what you need to do. So again, never transact for the trust without a letter of authority. I spoke about fiduciary requirements, so I'm not going to repeat this because I've spoken about it at length. I'm just looking at my time. So let's look at the benefits, the pros and cons and of creating a trust. First of all, you actually make sure that there is succession beyond death. I spoke about it earlier that you can transfer your legacy to your children using a trust. And you are in a position also to protect your children's assets by actually having a trust, especially minors and vulnerable beneficiaries. The next thing is if you're a business person, a trust actually helps you to separate your personal assets to your business assets and to actually retain your wealth as a business person. So it is always advisable that if you are a business person, try to separate your personal assets to your business assets, and you can use a trust as well to actually do that. Next one is there is centralized governance, and lastly, you can use something that is called asset freezing, or yes, estate growth freezing, when you have properly implemented your trust. And I will explain later on what this estate growth freezing means, which is one of the benefits of you creating a trust. Now, let's look at the cost or the risk. It can be a very costly exercise for someone who doesn't have enough funds or doesn't have enough money or assets to actually have in a trust. The next one is that the tax rate. If your personal marginal tax rate is 36%, and a trust is 45%, it doesn't make sense for you to move stuff from your own personal stuff where you are paying less tax into a 45% one. It doesn't make sense. The next one is in terms of capital gains tax as well. Trust have got a 36% tax rate on capital gains tax versus an individual who's got 18% tax rate for CGT. So one, you need to consider those two things, actually those taxes, when you actually want to either create a trust and move some of your assets into a trust for the future. The next one is that compliance can be an issue for some people, especially those that are not so organized, because you need to make sure that you prepare your annual financial statements, you file your taxes on an annual basis. So, and those compliance costs, if you don't have enough money, you might end up just paying and not getting the benefits. There are some companies that are charging close to 1,000 rands monthly just for the administration of a trust. No? So I've spoken about taxes. Let's look at yeah, I've spoken about the trust. There is a concept called the conduit principle. I don't think a lot of people understand the conduit principle, whereby the taxman provides a benefit to a trust and the donor and the trustees, where they say that the trust can be exempted from paying tax by using the conduit principle. Let's say you are going to receive a dividend. There is a company that is owned by the trust, and then the trust receives dividends from the company, and the trust pays distributions to beneficiaries. So what you can do is the taxman applies the conduit principle to say that I'm not going to tax the trust, but I am going, because the money came in and it went through to the beneficiaries, I am going to tax the income in the hands of the beneficiary at their specific rate. So they will use a flow-through principle to go and actually tax the beneficiaries. As an example, let's go back to an example whereby if the trust was supposed to pay 45% in terms of tax, in that year you decide to pay or to make distributions to the beneficiaries, and the beneficiaries have got different tax rates. So you can find that one beneficiary, which is a child, doesn't, or a young adult, tax rate is 18%. Can you see then you are actually saving by actually doing that distribution directly to the beneficiaries, because of if they have a tax rate that is less than the 45%. Yeah? So, and the important thing is, if it says that the income that the trust receives will retain its nature when it goes to the beneficiaries, meaning that if the trust receives interest, that interest will go to the beneficiary as interest. It will not go in as something else. It will go in as interest. Then there is a much further benefit that, remember, there is an exclusion of, in terms of the tax exemption, sorry, the exclusion in terms of the interest, anything that I think now is about 28,000. So you only pay tax after the 28,000. So the first 28,000 is not taxable. And then let's go back again to dividends. If it's dividends, it's going to retain its nature as a dividend. And if the company has already paid, has already applied the dividends withholding tax on the dividend, it means that when the dividends arrives on the beneficiary's hands, then it will not be taxed because you cannot tax it twice. So this is one of the nuggets that I'm giving for free today. So we can talk more about this. Talk to your tax practitioner if you want to apply this. Yeah? Then there is the section 25B limitation, which came through from 2025. And that principle says this principle, if a person is a non-resident beneficiary, this principle will not apply. So the 25B section only applies to resident taxpayers. So I'll go to the next slide. I spoke about the CGT and its benefits. Remember, when you are an ordinary person, I'll give you an example again. Let's say I'm owning a house in my personal capacity, and the value of my house is 5 million, and I sell that house. That house was my place of abode, meaning that when I calculate my capital gains tax, there's going to be a primary residence exclusion of about 2 or 3 million. Then on the base costs, on the capital gain, then there is also an exclusion of about 20%, meaning that only 80% of the capital gains is going to be taxed. No? So there is a benefit in you having a property in your own name. So that is number one. The second one, the contrast to that is you have got the property that is sitting in a trust. You sell that property out of the trust. Let's say you want to sell that property at some point. When you sell that property, that benefit of the exclusion, the 2 million, will not apply in this case because it does not apply to trust. It applies only to individuals. So that is one of the disadvantages of putting your primary place of abode in a trust, because you are losing out on that exclusion. So then we look at what is the tax, the maximum tax that you can pay on that. No? So let's look at the donations tax. If you were to do a donation to a trust, let's say you do a donation of 500,000 to a trust. You know that the first 100,000 is going to be exempt So meaning that there is no donations tax paid on the 100,000. So you are only going to pay donations tax on the 80,000. And that tax is paid by you, the donor, because you are the one that's making the donation. It is not paid by the trust. So that is another thing. So there is, and then there is a Section 7C loans, whereby a trust doesn't have any assets, it doesn't have any money, meaning that for it to start transacting, it will need to get some money somewhere. So me as a donor, I can make a loan to the trust. Then the trust uses that loan to acquire an asset. So loan to a trust, trust buys an asset. But what the taxman says, the interest that you are supposed to be paying, the interest that the trust is supposed to be paying you as the donor, if you don't charge them interest, is an interest-free loan, it's going to be deemed, there's going to be deemed interest. So then the trust will have to pay tax on the deemed interest. Or you as the donor, you'll have to pay tax on the deemed interest. So how you can actually circumvent that is to do a donation of that interest. If the interest on the loan to the trust is less than 100,000 and you have got interest of about 30,000, then that interest is not taxable. That is a benefit. If you want us to discuss it more, we can actually talk that, and I'll do examples. Remember, I'm not giving advice. I'm actually just talking about general knowledge here. So you can use loans to actually benefit you and your trust. This is another interesting one where you do estate freezing. What estate freezing says, I've got a property that I bought for 1 million. I bought it today. Then I transfer that property to my trust, or I do a loan to my trust, and my trust buys the property from me. So now there is an asset of 1 million and there is a loan of 1 million. However, and that property is inside the trust. That property is going to increase in value. However, the loan is going to be stagnant, because when you do interest, you do a donation. And if there is a repayment of the interest from the trust, from the rental income, or from somewhere, so your loan is going to go down, meaning that my estate, because my estate has got a loan, that loan will stay stagnant whilst the property value is going up. So that is what we call estate freezing. However, what you need to do, if you have got an existing property, you need to do evaluation of your property, determine what your tax costs are of the property, then sell or donate the property to the trust. Unfortunately, at that point, you need to pay the CGT. You cannot defer it. The date that you transfer the property is the date then that the CGT accrues. Then you sell you account for CGT and the donations tax and the transfer duties for that property. Then that's when the asset freeze takes place, and Bob's your uncle, your asset starts freezing. you need to sit with your accountant or a tax practitioner that can actually assist you in that process. Then let's look at what makes sense. What is the value of asset that makes sense for you to establish a trust? As I indicated earlier, I get people who will come and say, I want to register a trust, and you're like, what assets do you have? And a person doesn't even own a property, but they want to open a trust. So it doesn't make sense. So the first thing is, let's look at assets of less than 1 million rand. It doesn't make sense, or it's not economically viable to actually have a trust because there's cost to it. The administration costs us, returns, bank charges, and that. So that will eat into your estate, the hundred, if it's only 1 million. Nah? So let me also do a qualification. This, unless if that estate is for a special need or for asset protection of someone with special needs. That is my qualification. Then let's look at a band of between 1 million and 3 million. So you can do that, but you need to consider whether there's going to be much growth in your estate going forward, or what are you doing this for? Remember that the primary place of abode exclusion for CGT purposes. If you've got, if the exclusion is or the allowance is 2 million, it means you are losing out here by transferring your 2 million rent property into a trust. You are losing on one side. So you just need to be careful when you do that. It has to be purpose-led. The most viable one, I would say, is the third band, where you're looking at between 3 and 5 million. Here, you know that there is going to be, there is anticipated growth. You already know that I've got 1 or 2 properties, I've got other assets, I've got businesses that I want to put in here, and they are still at a very low, at a low asset value. So I can actually put it into the trust because I know that they're going to grow further. So this would be the most ideal time when you start considering a trust. Then you look at anything more than 5 million. This one needs proper estate planning, where we look at different aspects of estate planning, including including your trust. So this is what I would use as a decision test for you to decide when is the right time for you to register a trust. I hope this helps in one deciding whether they want to register a trust or not. So let me talk about special needs or special trusts. And this is a very underused tax planning tool or estate planning tool. I hope the ladies that I met in the last 2 weeks, some of them are going to see this, that if you have got a property, you can transfer that property for the benefit of your child into, you can register a special trust with the receiver, or with the receiver, yes, with the receiver, so that you get the benefits. Some of the benefits are you are paying medical expenses for that child through the trust. There's already a benefit for disabilities. We know that there's benefits for tax benefits for expenses incurred on behalf of someone with disabilities. Then there is other benefits as well. And what the taxman says, I'm not going to tax this trust at 45% like a normal trust, but I'm going to tax this trust at a marginal tax rate. Imagine the tax rate of that child whom you have created the trust for is 18%, meaning that you are going to pay only 18%. And there's also other benefits for that. So this is one aspect that I would like to have a special session for anyone who's got special needs beneficiaries, whereby I look at the benefits of a trust and the tax benefits of having that. So this is one of the underutilized tax planning tools. I'm going to end my session now. So what you need to do, you need to be able to choose a structure that is going to be beneficial for you to protect your assets. I indicated that an inter vivos trust is for now. You want to actually, you choose this if the beneficiary is still alive and they need financial protection today, or there is a disabled person who requires government funding, and or you have got assets that are already appreciating and you want the estate to freeze the estate duty, and you have got multiple businesses, and you want clear succession planning. So you are going to create an inter vivos trust. Then, and here, cost of establishing the trust should not be a consideration, because here you are not looking, you can't compare costs and what the benefits are, because here the benefits outweighs the cost of registering it. Secondly, is that if you have got a will, that there's going to be a testamentary trust whereby you can manage and protect the beneficiaries. You are doing it whilst you're alive, but they will get the benefits on death. The risk here is that where there is minor children or vulnerable dependents, there is a bit of a risk if you are only going to wait for this trust to be done at death. No? The last thing is you have a testamentary trust if you want to minimize lifetime administration. So what I would like to recommend is that you consider consulting with a financial planner or an estate planning consultant or a lawyer that can actually assist you with this, where you need your lifetime needs calculation, where you look at what is the best type of trust that I can actually do, and make sure that all your assets are actually included in the trust or even in your will, so that at death you can actually transfer them. If you have got policies, or if you don't have policies, go and take policies that can fund the trust on death, those kind of things. So just make sure that you consult with an independent financial advisor, as I said, or a legal expert, tax practitioner that can be in a position to do that. So lastly, if you're keen in taking the conversation forward, You're most welcome to take to email us at info@mmcpadvisors.co.za, or you can call us, or you can get in touch with us through our social media pages. I must say that this is quite a bit of a complicated matter. And what you can do if you need bespoke consultation, you are most welcome to contact us. And let me thank you again for joining us this evening, and all of the best with your financial planning and estate planning journey. Cheers.